Right. Hello. I think we're live. Hi, Marcus. How you doing?
Hi, thanks, Hannah. Afternoon, everybody.
Yeah, afternoon. I see we've got a couple of people already in the webinar. So good
Okay.
afternoon, everyone. Hi, Dale. I saw you were waiting patiently there. Yeah, welcome everyone to our landlord legislation webinar, evictions. So do you know where you stand? So just to start off, really, an outline of why are we here? So obviously at the moment we are still in a massive state of flux, aren't we, with legislation and with evictions, and we just felt it was really important to be able to get the message out to as many landlords as possible. I know I've been speaking to landlords on a one-to-one basis. I know, Marcus, you've had landlords that you've been having to deal with at the latter end, which isn't great. So we really wanted to come together, join forces, and get this information out there to you guys to make sure that you know where you stand right now. And obviously we'll be keeping in touch with you over the next sort of 3 to 6 months. There's no doubt things are gonna develop.
It's a fast-changing pace at the moment. So yeah, it's going to develop on a week-by-week basis pretty much.
Yeah, absolutely. So just to introduce myself, I'm Hannah McCartan, the Managing Director of McCartan Lettings. Been going for 15 years and specialising in residential lettings market in Swansea. So I think probably most people here on the webinar know who I am. But I'm joined today by a good friend of mine, Marcus Brace, who is an absolute specialist in property law sector. So you crack on with introducing yourself too.
Thanks, Hannah. Oh, well, I hope I can live up to that sale pitch. Well, my name's Marcus Brace. I'm a solicitor at CJCH Solicitors and based in Cardiff. We've also got offices in Barry, Blackwood and Bridgend. I've been involved in property law right from the very beginning as a trainee solicitor, and since I qualified in '96, which was quite some time ago. So I deal with both commercial and residential property law, including possession claims. So I've been dealing with both commercial and residential possession claims for a very long time. As a landlord myself, I'm also very keen to ensure I know what my rights are as a landlord to evict a tenant, either using Section 21 or using Section 8. And of course, that knowledge does come in handy when it comes to advising clients on a successful possession action. Thanks, Hannah.
Fab. So, guys, this is just whenever you're going to get another a free hour with a solicitor, isn't it? So do ask as many awkward questions as you can. On that note, actually, I'm just going to introduce Abby, who's in the background. She's our tech support today. So, Abby, if you want to give us a little wave in the chat box there, so she'll be helping us with any sort of questions that you have. We will have a dedicated question and answer time sort of 3/4 of the way through this webinar. Hi, Abby. So just to give a little bit of housekeeping as well, on the, get my left and right now, right-hand side of your screen, there should be a chat box. You'll see that next to the chat, there is a poll and handouts. We will be doing a poll to keep you on your toes, so watch out for that. And there will also be a handout at the end, a bonus guide of how to kind of navigate your way through these times. So we really want this to be interactive. We can help we'll help as much as we can. Hopefully this webinar will answer quite a lot of your questions. So what will we be covering today? So notice periods pre-March 2020. So let's just sort of establish what it used to be like. I don't think we're ever going to go back there again, but let's sort of set the basis. What then happened with notice periods from March? March was pretty hairy time for landlords and property professionals trying to get our head around what was going on. Then we're going to touch on the impact that has now had on landlords, what landlords now need to have in place, because it's not just about how the legislation is working, it's what you need to now have in place to serve your notices if you need to. Then we'll go into a question and answer session. I'm going to touch again briefly on the Welsh tenancy saver loans. and professional management rent guarantee policies. So, oops, my slides. So let's get stuck in. Notice periods before March, it was pretty standard, wasn't it? I think it's been like this for a fair few decades. Can I go that far? That it
1988, yeah.
Thank you. So 2 months notice for Section 21 to get your property back. Nice and easy, no reason needed. And if you were in a rent arrears situation, you could use Section 8 ground date and it would be 14 days. So again, relatively straightforward on that. And with Section 8, you can claim the rent back through the courts. Section 21, you can't, but you've got possession. So, you know, you've got to sort of weigh it up how you want to use that. On the 18th of March, that was a bad day. The government said, because of COVID, because of the lockdown, the imminent lockdown, we are going to stop any evictions indefinitely. There was no light at the end of the tunnel on that. And we were all scrambling around thinking, what the hell is going on? This is now the end of the world. However, on the 26th of March, they then gave clarity to that, didn't they, Marcus? They then said, actually, make it 3 months. So do you want to kind of take us on the journey from there? What happened?
Yeah, by all means. I'll also touch, obviously, on Section 8 notices as well, because there's a huge amount of confusion in the law between England and Wales. Obviously, housing is a devolved matter. It's given to Welsh Government. However, the Coronavirus Act 2020 was the first piece of legislation put through Westminster on a devolved matter for about 10 years. So that applied across the country, but with provision for each of the devolved governments to make their own laws. So obviously, as you touched on, Hannah, prior to the 18th of March 2020, everyone was quite comfortable with the minimum 2 months notice for a Section 21 notice, and obviously the notice periods in relation to Section 8 were quite clear. They're all set out in the Section 8 notice guidance notes. Everyone knew where they stood. On the 18th of March, there were publications being issued, statements effectively by the Housing Secretary, Robert Jenrick, just simply saying evictions are going to be banned, which of course frightened everybody. And when the legislation came out, and they said, "Oh, it's only 3 months. That's not too bad. It's only an extra month, you know, to serve your Section 21 or your Section 8." So that's not too bad when it was clarified on the 26th of March through the implementation of the Coronavirus Act 2020. Of course, following that, on the 26th of March, on the 24th of March, let's go back, 24th of July, Welsh Government introduced a statutory instrument under the Coronavirus Act saying, look, we're all going to change the notice periods for Section 21 notices and Section 8 notices to 6 months. And of course, because it was a statutory instrument and the Coronavirus Act gave the government authority to introduce it, it was introduced in next to no time, literally 4 days, start to finish. And so it took everybody by shock, really, as to how they can change things so dramatically. No fault evictions has been an issue for Welsh Government for a long time. And it's something which they wanted to change. And this gave them the power to do it. Whether it will change back, I don't know. But I'm deviating on this point at this stage. So there was a lot of upset. 29th of August, England introduced certain relaxations for substantial rent arrears. That wasn't introduced then in Wales because that was under the English jurisdiction. But on the 29th of September 2020, we did have a further statute which was introduced. And one of the things that's actually not been mentioned anywhere, I've seen one sentence on the Government Wales website, and that is, if you're looking to evict for antisocial behaviour under Section 8 notice, ground 7A and 14, then basically from the 29th of September, it said the Coronavirus Act 2020 doesn't apply. So it's actually gone back to the Coronavirus Act 2020 timescales. And not many people know that. But the problem is you've got legislation being produced in England, legislation being produced in Wales, differing guidance produced by different bodies in England and Wales. And as a consequence of that, there is a huge amount of confusion over what notice periods are, and also what the notice periods are for section of the various grounds under Section 8. So yeah, it's even it's difficult for lawyers to keep up to track with the fast-paced legislation. I should imagine it's an absolute nightmare for agents and lay persons. So I don't think that a lot of time and attention is given by sort of national providers of information, particularly to devolved states on these rules and regulations. And it does take a bit of time to actually sit down, read through each piece of legislation and try and piece it together. I don't know how you find it, Hannah.
Yeah, well, it's just constantly keeping up to date with the news, and when we get the news, it's then reading into it and spending the time and then sharing that information as quickly as possible. I remember the 24th of July, vividly, it being a Thursday, hearing the news at 4:30 in the afternoon that our notice periods were going up to 6 months. And I thought, oh, Jesus, here we go. And within an hour, reading it all, speaking to a couple of people, you know, in my professional networks, and then getting out on social media, on video, letting as many people know as quickly as possible, because it has an instantaneous impact on how we run our properties. So yeah, it's been heavy going. And of course, those landlords who have had notices served, Section 21, that then expired in lockdown, and then there was that whole hoo-ha of, oh my, do you have to reserve? Yes. So yeah, I think that goes sort of nicely onto, you know, the impact that this has all had on landlords, hasn't it? I mean,
yeah,
the landlords we got sort of two sides of this, isn't it? It's non-payment of rent. That's the biggest crisis that landlords have right now. So we had the landlords who had rent arrears prior to March, trying to get possession of their property back. And then we got landlords in lockdown where their tenants are starting to struggle to pay rent. And to today, isn't it, then tenants who aren't paying rent, who have just started to default. Because it's this 6 month notice period, isn't it, that you have to wait still 2 months for your tenant to be in arrears to then serve 6 months notice on them. And you have to have all the paperwork in place as well. And we're going to touch on that in more detail shortly. But yeah, it is just, you got a backlog in the courts as well.
Absolutely. The courts are struggling. Yeah, no cases, no eviction cases have really been progressed since the 26th of March. And in September this year, the court said, right, okay, you can we can start dealing with possession claims. But they have to say, well, what they've said is, look, you've got to file a reactivation notice, and it's got to be filed by the end of January 2021, I understand, and to get your case going again. But even then, it's going to take months to push them through, except for certain cases like antisocial behaviour. So it is a very difficult time. It really is for landlords, because you've got some tenants who are genuinely in financial difficulty because of COVID-19, and you've got to empathize with them. You really do, because it's a very difficult time. But you have other tenants who see this as a rent-free period, and those are the landlords who are suffering, because at the hands of unscrupulous tenants, potentially, who probably don't have an awful lot of money, and they're probably not going to be worth suing in the long run. So you have a situation where a landlord has a difficult choice whether to swallow the bitter pill of letting the tenant go without paying rent, or incurring the cost of going through possession proceedings, but there are set procedures that you have to follow as a landlord in relation to any form of eviction, more so over and above that than that which was in place previously, which we'll touch on in due course.
Yeah. And just to touch on the confusion again, the side of things, I sort of mentioned notices expiring in lockdown. In the press a couple of weeks ago, there was what looked like a loophole to there being 6-month arrears. Then you could reserve your section notice, and then you could then have a 4-week notice period again. So that's still, yeah, it's just confusing, isn't it, for the English landlords, for Welsh landlords, what is right for each side. So, and again, that was sort of under great debate then. We're going to do a poll now. I think, I think
that's about right time. Yeah.
Do the poll. So let's, Abby, if you can get that poll up for us. Marcus, do you want to read? This is Marcus's question, so I'm going to let him read on this.
Out of interest, we might have given the answer away already, but the question really is, do you know the notice period for serving a Section 8 notice in Wales for substantial rent arrears? So
give you, I don't know, 10 seconds?
I'll give another couple of seconds, I reckon.
Am I really harsh? I'm like, know your answers.
Do a countdown.
Okay.
Okay.
It's really interesting, actually. So yeah, we've got a couple of people, 2 weeks, 3 months, 6 months.
Yeah. Yeah.
Any more for any more. Who have we got in the room?
So we got 14 answers.
Mikey'd. Have you answered? Nice to see you guys here, by the way. Give me a wave. Okay, so
in Wales, it's 6 months. Yeah.
6 months.
Yeah. So this is the thing. It's quite reflective of the mishmash of guidance out there, and also there's when people research things on the internet, such as notice period, make sure you use your tools and look at the information provided, say, within the last month, because you could be looking at historic information.
Yeah. And I'm just going to give a sort of a live example of a landlord that I've been working with just recently, just to kind of put this into perspective. And I don't mean to scare the living daylights out of anyone here, but this is just the reality of the situation that we're in right now. So we had a landlord, self-managing landlord. We set up the tenancy, professional, single lady, and she went through referencing fine. This is at the beginning of lockdown. And after about 4 months, he contacted me and said, I'm a little bit concerned and I can't get hold of the tenant. And the reason he was getting concerned is obviously because not being able to get in to do your quarterly property visit. You just want to make sure, is your tenant okay? We're in the middle of a pandemic. Is the property being looked after? Can she do me a video walkthrough? You know, just these questions, but there's been no response. And I said, well, just, keep me posted and keep, I will be, helping you if you need it. And of course, a couple of weeks later, he phones to say the rent hasn't been paid. I said, well, okay, well, you know what to do. You're self-managing, you've got your processes, your letters, your checks, so on and so forth. But she had gone completely to ground. 2nd month is missed. And suddenly we are now in this realization window that if we cannot get hold of this lady, that it's an abandonment situation on top of rent arrears. So we're looking at, he's now 2 months in arrears. And this is not a 2 up, 2 down in Mount Pleasant. This is a substantial property with a substantial rent. 2 months rent arrears, to then serve 6 months notice and obviously pay Marcus for his time in doing that. And then waiting after that notice has expired. Now, bearing in mind it's an abandonment, we can't discuss anything with her, to apply to a court. The court order, then, as you were saying, Marcus, isn't it? The courts aren't doing anything from March. They haven't done anything really substantial yet. So then let's just add in the backlog. And let's just assume then that's another 6 months waiting just for a court date. Then, because the tenant still then doesn't leave after you'll surrender the property at the end, because she's not in contact, then you have to wait for a bailiff. And I know we've got Jan Martin on here, and I know she's been through the mill with some of these situations. So Jan, you're really going to know what I'm talking about here. That everything has just been extended. And then you have your bailiff appointment to then obviously go in and formally get possession of your property back. And that is just the scary reality of where we're at, and having all of the paperwork to back all of that up. Thankfully, because we were contacting her employer, her next of kin, her parents, her last address, we were able to get in contact and say, you know, what's going on, and negotiate a surrender of tenancy. But that landlord got off lightly, and is well, now actually coming on full managed, but that's aside, because he can't deal with the stress of that again. I mean, hey, this is what we do, but it can happen to anyone. I think that's my point, that at the moment it is sort of the Wild West out there, isn't it? And it can happen to anyone. So let's get stuck into the details. So I hope everyone is got their coffee, gonna be nice and settled into this now. So yeah, Marcus, take the lead on this.
Thank you, Hannah. Yeah, on the 17th of September, the head of civil justice, known as the Master of the Rolls, bit of an archaic name, issued something called the Overall Arrangements for Possession Proceedings. And the purpose of this paper, issued by the head of civil justice, was to tell landlords that they had to follow certain procedures if they wanted to evict a tenant, either under Section 8 or Section 21. One of the requirements that they've said that landlords must follow are inquiring into your tenant's circumstances to determine whether or not they've been affected by COVID-19. So if you're thinking about evicting a tenant, you have to adopt this new touchy-feely approach rather than just serving a Section 8 notice saying, we want the house back. So you have to inquire of the tenant and ask them whether they're facing hardship because of COVID-19. If there's rent arrears, an important factor here is, was there rent arrears before the 23rd of March, 2020? Because if all the arrears have occurred after that date, then in those circumstances, the courts aren't really going to prioritize your case, and they're going to be very lenient with the tenant. You may not get a possession order, you may get something called a suspended possession order or something like that. So the type of thing that you need to know about your tenant is whether they're on furlough, whether they've been placed on universal credit. Has the tenant been unable to earn for some other reason? For example, have they been shielding, or indeed unwell or isolating? Once you've got all that information, the next obligation is to discuss with your tenant a payment plan to pay the rent and arrears. So this is an obligation on landlords. Whilst it's not set in stone in any civil procedure rules issued by the Ministry of Justice at this stage, it's not going to be long before it is, in my view. The backlog of cases are going to take, I reckon, 12, 18 months to clear. The judiciary are allocating 200 judges just to landlord and tenant matters. And they're also prioritizing the type of possession claim according to the basis of possession. So it's going to be the case that if you get into the court, they're going to ask you, what information do you know about your client's circumstances vis-a-vis COVID-19? And you have to answer all these questions. Obviously, if the tenant doesn't tell you, you can't say anything, but you need to show to the court, if you are going down that route of having to issue possession proceedings, that you've made that effort. So I think certainly as an agent, I would be having a standard pro forma inquiry letter. As soon as you've got a tenant in arrears, it automatically goes out. Are you suffering from COVID-19 related issues? Please tell us. Please let us know so we can deal and adopt this touchy-feely approach that the head of the civil justice want us to adopt.
Yeah, so, definitely. I think that goes for all landlords as well, isn't it? It's just the moment you have any communication right now with your tenants, document it.
Absolutely. And of course, this brings us on to the next step. The overall arrangements for possession proceedings was prepared as part of the working group on possession proceedings. And part of this working group was the National Residential Landlords Association. And part of these overall arrangements was the requirements for the NRLA to issue guidance to landlords. And there were two sets of guidance. One was the 9 golden rules, which are a handout which Hannah's kindly provided at the end of this webinar. The second one was the 5 steps which, as a landlord, you're required to take before you're able to serve, not just seek possession, but to serve a Section 8 or Section 21 notice, and they're sort of summarized there on the screen for you. So effectively, you need to write to the tenant outlining your reasons. Obviously, if you want to sell the property, it's black and white. But if possession is for arrears, then the arrears pre-action plan should be followed, i.e. asking them whether they've been affected as per the previous slide and whether you've got a plan for them to pay off all or some of the rent and arrears. It says that a failure to do so could result in your case being adjourned. So that's just only going to lead to further frustration for landlords. When you come to serve your notice, you must consider or declare any information that you know about the tenant, their dependents or family being affected by coronavirus and how it impacts on their ability. You need to resolve issues through discussion and negotiation. And as a landlord, you have to consider any representations received from the tenant. And all this information may be requested by a judge in possession proceedings to check that you followed these steps before you've even commenced your possession proceedings. What impact it will have in the possession proceedings if you don't follow it is not clear at this stage, because obviously seeking possession is a legal right. I suppose the question is whether the judge is more willing to grant a suspended possession order on payment of rent and payment of a contribution to clear the arrears of rent ultimately. And of course, because of this requirement to produce to the court evidence that you've complied with these 5 steps, you need to document everything so you can show to the court that you performed it, you performed the steps. So that's where we are. So there's an extra step in the process before we even get to serving a notice. And I think that's intentional by the judiciary, because they want to string out the number of possession proceedings being submitted to the court. So it's
a massive bit of information for landlords to take away. If nothing else from this webinar, it's that one thing that there is so much more prep required now before you even get to serve the notice. So yeah, absolutely.
It's more standard forms to send to the tenant.
So yeah, sorry, I went on to this slide a little bit early. So then what do we need to do? Let's just sort of recap now what actually needs to be done, because to go to court and then find out that you've not completed one of these things and you get sent away and you have to reserve a 6-month notice period does not sound like fun to me. So
yeah, I think
that's what we need to do.
Well, I think that's right, because I can't see in Wales that the 6-month notice period is going to go away. It's my instinct is that this 6-month notice period is probably going to be enshrined in Welsh legislation in due course. But if you are to serve a Section 21 notice, you have to make sure that the Section 21 notice is valid. So you need to make sure that you protected any security deposit, that you've given the tenant and the deposit payer the prescribed information within the required period, terms and conditions of the tenancy deposit scheme. What evidence have you got to show that you've actually served it on the tenants within the required timescale? Do you get your tenant to countersign and date? Because if a tenant disputes that they haven't been given the prescribed information, that could be a significant obstacle for your possession claim. So obviously, as a landlord or an agent, you have to be licensed with Rent Smart Wales, and obviously as the property owner registered. If it's a house in multiple occupation, you must have a HMO license, and obviously be mindful of the ability for local authorities to issue additional licensing for HMOs in certain areas. I know there's mention of St. Thomas currently being introduced, so you don't want to miss the boat on that one and look to serve your notice and find out that actually your property should have been HMO registered and you didn't realize that this additional licensing area was declared by the local housing authority. And lastly, if you've made a prohibited payment, then obviously you have to pay it back. This isn't an exhaustive list. These are the key issues, but you have to have a look at your tenancy paperwork and how the tenancy was set up and created, and all the requirements met on a case by case basis. So that's essentially the key ones. And obviously, when you get to issuing a possession proceedings, you've got two options. If you're serving Section 21, you've got your accelerated possessions procedure, and you've got your standard possessions procedure. I always prefer the accelerated possessions procedure, simply because it's black and white. If your paperwork is all in order, then in those circumstances, the judge has got no discretion but to give you an order for possession. The only discretion the judge has is to extend the period of suspending the possession order in the event that a tenant seeks some leeway from the court on the basis of hardship. But you need to have a written assured short-hold tenancy agreement if you're using the accelerated possessions procedure. If you don't, you have to use the standard possession procedure. And the problem with the standard possession procedure, it is longer, but also the tenant can bring other issues in to the proceedings, which may bog everything down, such as Section 11, disrepair claims, and so on. So that's always a nightmare for a landlord. When you're filling out your form for accelerated possessions procedure, N5B Wales, you've got to provide a copy of your deposit protection certificate, and you've also got to provide evidence that you served the Section 21 notice. I see that there's guidance online which says that a landlord should fill out a certificate of service, which is a form freely available on the court website. But I don't think there's any better proof of service than getting a tenant to countersign the notice. And I always prefer to serve the notice personally rather than sending it by post and recorded delivery, simply because you've got first-hand knowledge of where the letter was sent and the date it was given. Because obviously there's one thing that tenants will always try and wriggle out of if they've got some room for manoeuvre if all your paperwork is in order, and that is, I didn't receive the notice. So that's about it in a nutshell, really.
Just in a nutshell, hey. One thing I'd like to just add about this evidence you've served Section 21, I do it slightly differently. So, I can't imagine, Marcus is pretty scary turning up. I'm not as scary as Marcus turning up on somebody's doorstep. So another way of doing it, and especially sort of in lockdown, is we serve it first class and get proof of posting. And also at the same time, we send it for special delivery as well. So there is that signed for element. So that is always a great debate between me and Marcus as to what the best thing to do is. And as you can probably tell, we're pretty passionate and love what we do when we get stuck into these the nitty-gritties of it. So I guess the overall thing though, is that this is just massively overwhelming for us landlords. I think anyone who's in property right now, is finding it hard to really know, where they stand, and what to do if every situation is unique. I think that's the thing, isn't it, Marcus? Is that we can't give all the answers because everyone's situation is different. Every tenant is different. But the main thing is keeping in contact and keep communicating with each other. We have a Facebook page, Swansea Landlord Circle. Abby, if you could pop a link in the chat on that, if anyone is interested in joining. It's just for Swansea community landlords to get together and discuss their issues. We're also offering a free 15-minute consultation as well. So if you're a bit sort of shy about putting any comments in the chat or any questions, and you want to talk to me, Marcus, outside of this webinar, there's a link going in the chat there as well. So please do take advantage of this. Again, we're wanting to help our people, our community of landlords, get through these really stressful times. So let's just recap on the main points before we go into Q&A. So get your thinking caps on and get your questions going in now. So we've established that before it was really straightforward. It had been like that for a generation of 2 months notice on a Section 21 and so on and so forth. We've had many, many changes, very frequent changes, some with no notice at all, which has put our industry in quite a bit of chaos. We have to provide lots of information and source information. We have to get evidence now to know what your tenant is doing. Is it a rent payment holiday that they're looking for? So you can do a rent payment plan. You've got to have that documented. What if they default on their rent payment plan? You've got to have a process in place to make sure that you are protected should the worst case happen. It's all well and good taking somebody's word for they're going to pay you back, but let's just make sure that it is absolutely watertight should we need to take it forward to get to possession in the courts. Yes, and then we're hearing, aren't we? Then if you're sort of serving Section 21, you've got to make sure your file's up to date. You've got to make sure that you have everything in place. And again, happy to help through doing any sort of consultations on your file as well. So we've done that for a couple of landlords, and we found a few gaps that could have, been a bit of a sticky wicket for them. Not just for Section 21, actually, for that matter, because some other things start to come out of the woodwork. But that's fine. It's asking for help, isn't it?
It is important to make sure that all your paperwork is right, because one of the things that you have to be aware of under the overall arrangement is that tenants are going to get non-means tested free legal advice through the duty solicitor schemes at 2-stage during any possession proceedings. And that's a review date, which is 1 month before the substantial hearing of the matter and at the hearing itself. So it's going to be a situation you're going to be up against the duty solicitor who'll be very well versed in landlord and tenant matters and will probably know the legislation. So it's extra important to make sure that all your paperwork is in order, all your evidence is in order. Yeah, sure.
Absolutely. Fab. Okay, so question time.
So I've seen the question from Dale.
I was just, I just saw that, right. If I read it out, I think this might be one for you, Marcus. I wonder if you serve a Section 8 on grounds 8, 10, 11 and 14 and take it to court on ground 14 for speed. It's obviously a discretionary ground, so the judge has the responsibility of delays. Will a judge be obliged to consider grounds 8, 10 and 11 when we get to court on ground 14 as ground 8 is mandatory? Great question, Dale. And that's the kind of level of thinking all landlords need to be at, isn't it? You need to know your numbers.
Yeah, absolutely. So obviously, my greatest concern about mixing and matching various different grounds is that do you invalidate your notice if you issue court proceedings too early if you've added all the additional grounds in? Because obviously under section ground 14, you can serve your notice, and then you can pretty much commence proceedings right away, because we're back to, in Wales at least, pre-COVID time periods. Whereas for any other ground except 7A, it's rent arrears. Now, part of the overall arrangements is that there's a priority in which cases are going to be heard. And rent arrears are not really high on the agenda in terms of being listed to be heard or considered by a judge, unless it's cases of extreme alleged rent arrears of at least 12 months rent or 9 months rent, where that amounts to 25% of the landlord's income from all sources. So if you're just going on the basis of 2 or 3 months, your possession proceedings aren't likely to get listed for quite some time. So if I was in your position, I would be doing section 14 and getting into court right away. And as a point of antisocial behavior, I think if there's breaches by the tenant of coronavirus legislation, then I think that also is very relevant and very pertinent. And because why should the landlord suffer from a tenant, say, who spits at people or something like that, or such other egregious behavior? I think those are the type of cases which are going to make it through the courts a lot quicker in Wales. So I think ground 14 all the way. I wouldn't necessarily worry about the rent arrears grounds at this stage, unless they're pretty serious and you can show that the rent arrears accrued prior to 23rd of March 2020.
Yeah, and I think that kind of goes on to your next question, Dale, is if you formally defer rent, it cannot be legally due. My understanding of it, I wouldn't formally tell a tenant that they don't have to pay rent, or I guess if it's deferred, you would have it in writing that it's a payment plan. So you say, okay, you can pay half rent for 3 months and then you pay it back over 12 months. That's the payment plan. So I don't think, you could use that unless they then defaulted on that payment plan, and then it defaults back into payment arrears, doesn't it then? And then, but it is very long-winded and complicated.
Strangely enough, I've done a lot of letters deferring rent on commercial matters, but not on residential matters. So there are standard forms of letter, which are about 2 pages long, which sets out all the terms and conditions if you're looking to defer rent and then seek to have it paid at a later date. Or not, as the case may be.
I'm going to go scrolling up to the top. I've just read Keith's question. I'm just going to read it out. Keith has a tenant who's totally refuses to pay any rent since February. She moved out of the flat in June with all of her furniture, but refuses to hand the flat back to me. So I'm wondering where I stand with this, as I can't get access to the flat for any maintenance. As it stands now, I don't know where she is living. I think you've got quite a few different things going on here. Formal possession of the property back is the biggest thing, but your responsibility as a landlord to do maintenance as gas safety is the biggest thing that I'm seeing there as the priority. So you can gain access to a property for things like gas safety certificates, absolutely. The fact that she isn't there, you would still go through the process of though as if she was there. So writing to her, emailing, text message, voicemail, do as much as you can to prove and document that the gas safety is due on the 27th of November. My gas engineer is coming round on the 26th, or whatever the case may be. You probably want a little bit more time than that. And just document everything. But that gas safety certificate must be done. I mean, again, serve notice. It's a rent arrears thing. And it's very similar, I guess, to the story that we've just resolved before. Where does she work? Phone her employer. Have you got next of kin details? Did an agent set the tenancy up? Can you go back to the referencing paperwork? Again, for employer details, next of kin, previous address, previous that. You just don't know. A Facebook. I mean, just don't go stalking, but it's
extreme liking, I think it is.
Yeah, so I think Keith, book in for a 15-minute chat. Let's have a quick run over your file. I'd love to be able to help you with this, because it sounds very complicated, and I can't imagine how stressful that is. So we'll definitely get you helped on that.
Yeah, one thing I would like to add on that is just make sure all your tenancy agreements have a clause in them which allows you to recover legal costs if you have to take steps to enforce any breach, because that's a huge bargaining factor in negotiations with any tenant, because the tenant doesn't want to face thousands of pounds worth of legal costs if you are forced to instruct a solicitor. So as part and parcel of these planning arrangements regarding paying rent for to comply with the overall arrangements, you can say, look, I don't want to incur legal costs. Let's try and do it amicably. Let's try and agree a time that you can sort of vacate the property and pay arrears and so on. That would be the better way of dealing with it. Ultimately, if you haven't got a tenant that's going to go, this is going to sound like a bitter pill to swallow, but I know in Keith's case, offer them some money to go and just hand back the keys. If they're not in there, it's free money.
It's all about the keys, isn't it?
Yeah,
it really
absolutely. Because under the Housing Act,
negotiate.
there's two ways you gain possession currently in Wales. One is a possession order enforced by a bailiff. Secondly, is a surrender. And if you've got to pay some money to get the tenant out, it's a bitter pill to swallow, but it's far cheaper than going to court, and it's going to be a lot quicker. And you can rent your property out a lot quicker as well.
Yeah, absolutely, all the way. And hopefully next year, when we get the Renting Homes Act coming into Wales, I know there's a big hoo-ha. This is totally another seminar I'm sure we'll be doing again. Next year, they actually have abandonment clause in there, which will be absolutely fantastic. And actually, this will completely mitigate this situation. Yeah. 28 days, you legally take your property back. So I'm really sorry this has happened to you, Keith, this year. If it happens next year, you can rely on different legislation. So there is a bit of a light at the end of the tunnel with these changes.
Yeah.
Going to move on to George's question. Can she serve a Section 8 notice if I'm not licensed with Rent Smart Wales? Interesting question.
Okay.
Marcus, do you want to lead on that?
There was a case which recently went through the Welsh courts, went up to the Court of Appeal, which said, look, if it's a criminal act, if you serve a Section 8 notice, because you're in breach of the registration requirements, it's not a valid notice. This is effectively what the court decided. I find that a little bit hypocritical, because there are other situations where the courts have said you can acquire legal rights, even if the activity that you do is a criminal offence, and typically rights away with vehicles over common land without lawful authority. So I'm a bit surprised at the court's approach. It's inconsistent. I wonder whether or not there's going to be another decision to come out of this. But the question is, who's really going to have the money to take it all the way to court? And of course, I think I read the case, and I think Shelter Cymru intervened in this case as well. So obviously they're trying to introduce case law which protects tenants. But interestingly, there's a couple of points which I looked at, and that is, well, what about property management work? Because there is one exemption to being licensed for property management work, and that is if you do one thing only. So what would be the position if a landlord who wasn't registered instructed a solicitor to serve a notice? And that's all the solicitor did, nothing else, just serve the notice, because the solicitor wouldn't need to be regulated, and that would be a valid act. And it'd be interesting to see whether or not that is a loophole to overcome the current case, which is being bounded about in the media, saying if you're not licensed, you can't serve a Section 8 notice. I've actually been in front of a judge on this very point, and I convinced him that it was valid. And I got the possession order. So just based on the fact that I served the notice, and it was perfectly legal for me to do so.
Yeah.
So,
that's
but there we are.
Isn't it?
It may differ in the next case.
Yeah, I think from like a more normal, everyday kind of perspective, if you don't have a landlord Rent Smart Wales license, you're likely to have a managing agent or someone who has a license, who has an agent license, like a family friend who manages a couple of properties for different people, like a low level kind of agent, or as you say, a big manager. So it would be odd that a landlord would want to serve notice without a license. You would ask your managing agent, or if you weren't confident in their ability, you would have these conversations with your agent. But certainly don't crack on without getting professional advice first, because 6 months, it's back to that thing again, isn't it? You're serving 6 months notice, and for it to be thrown out and having to be reserved properly, you're only going to lose out. So just have the conversations before taking any action.
Absolutely.
On that, I'm just going to mention.
There's one other question I've seen from Mike, is it? But it was regarding an English tenancy, where he said that he didn't get a energy certificate and serve a government handout, the rent guidance form for a property in England. I have looked at that on a particular point, because I'm in the process of serving Section 21 on a property in England, and there has been some case decisions on that. If you want to Google them, and I think the outcome of the case, the decision when I last looked at it a couple of months ago, so I haven't updated myself on this particular point, so you can't rely on this, but I think the courts actually turned around and said it's fine to send it afterwards, but provided you do it before you serve the Section 21 notice. Okay.
And the final question I saw in the thread was, can you still, no, sorry, I've lost it now. Bridget, there we go. What are the notice requirements and steps to follow if you need to sell the property? So I thought that was a really good question, because
I'm in exactly the same position. I'm doing that now.
Get me out of here now. Because we've been focusing on rent arrears, because that's kind of like the biggest risk of it all. But actually, these are our properties. If we want to sell them for whatever reason,
Yeah.
At the moment, it is still 6 months notice. It is still the same process. And hopefully, again, with communication with your tenant, to speak to them or get your agent to speak to them, explain what your situation is, you might find that they will leave early. But more than likely, your contract will state that marketing can only commence in the last 2 months of a contract. So it's twofold then. You have to serve notice and wait 4 months before you can actually put it on the market for sale. For the tenant's perspective then, that's quite a lot of anxiety to be having, being in a 6 month contract, knowing that you can't make it your home. And more often than not, I suspect tenants will be coming in saying, well, actually, can I leave a little bit early, please? Because we found another home that we can go to. So those are the steps. You still need to follow the legal process, but I would certainly add in there, having an honest and open conversation with your tenant will go a long way, especially if you need to sell quickly. There's no guarantees, of course, but it will certainly help. So I hope that's answered your question there. Thanks. Yeah, no problem.
Richard asked a question about do all these points apply for Section 21 notices in England. Obviously, Section 21 in England is a completely different ball game. You have to serve Form 6A, and the hurdles that you have to overcome to serve a Section 21 notice in England is extreme compared to Wales. So thank goodness for Welsh Government keeping the Section 21 process relatively simple compared to England. So that Section 21 in England is a separate seminar subject all on its own.
It is, yeah, and one I am not holding. We'll leave that to another agent to do that. Yeah, we've got a Renting Homes Act coming in. I'm gonna focus on that. Very quickly, because we always knew we were gonna romp through this hour really quickly. Welsh tenancy saver loans. So I've had a couple of landlords come to me and say, well, none of this really matters now because the government are giving away loans to tenants. So surely my tenant can just get a loan and it will solve a problem. The problem we have found when we've read through the criteria is that if your tenant is on any type of benefits, then they're not eligible to receive the loan. So if you are thinking this is a bit of a buffer against these risks, then you might need to sort of think again. And again, you don't know, unless you're going to have these conversations with the tenants, you don't know if they're going to be on benefits, more recently. So I'm talking about sort of, the professional tenants who are being made on furlough or being made redundant. So you really do need to be having these conversations. And if we think back to one of the first slides that we did, when COVID first hit and furlough started, and tenants were struggling to pay their rent, all the guidance was telling us to advise tenants to go on universal credit. And if a tenant's on universal credit, they are not eligible to get the loan. So that was a bit of a blow when we kind of read that. So I just wanted to make you all aware that it is not a black and white situation with that. So kind of leading me on to rent guarantee policies as well. For landlords on this who know me very well know that I've always been, since 2006, as McCartan Lettings first was established, we had rent guarantees for every managed landlord because I knew they were so important. They've never been more important now. Yes, they've gone up in price. But if you consider a couple of £100 for a policy and your rent is £650, these policies are going to be paying out for, up to 6 months and cover legals. And it's just having that protection there. And I'm not saying this to kind of sell a product or anything like that. It's not about that. It's just being aware that these products are out there and they've never been more valuable. Just the cost of serving notice, isn't it, Marcus, for you is a couple of £100. In fact, it's kind of the same price as a full rent payment guarantee product and legals. So it's just really taking stock. If you've always thought, well, it's not for me, the landscape has changed. And another thing is professional management. Having landlords coming over to us now because the stress levels are just too high. And as a landlord myself, as many of you know, I don't manage my own properties. Good God, that'd be way too stressful for me. I've got my fabulous team in our Calais office running my portfolio because I need to have a clear perspective and let them get on with what they're best at. So it's really reviewing your portfolio right now and having conversations and really thinking, where do you need to position yourself? And professional management is a way to really protect yourself, because I will then be taking on that liability. I will be making sure that your file is 110% compliant. We have best practice status with Rent Smart Wales, so they've teared us apart to make sure that we do what we say on the tin. And should the worst happen and we need to go to court to get possession, then Marcus knows that everything in our file. In fact, you have worked on one of our files before, haven't you? We shouldn't go into this. In fact, we're over, so that's good. And you couldn't find fault, so I'm going to slip that in there. Well,
I knew I had a challenge because you were the agent, so yeah.
Thank you. It was good fun. So get the bonus guide in the handout. Please connect with us on social media. Abby's going to pop our direct emails in here. You've got the link for a free 15-minute call and access to our Facebook groups as well, so we can carry on this conversation, keep helping each other, and just, I think, be a community of people going through very similar things, isn't it? And if we can support each other, if I can help one or two people who are really struggling right now, then it's all been worth it. So yeah, did you have any closing comments, Marcus?
No, not really. I think you've covered it all. Actually, I think we've covered a lot of ground so far in this webinar today. So just a taste of what we've got to deal with, really, in this new landscape, and the difficulties that every landlord now faces, effectively, if they've got a tenant who's a problem tenant and in arrears. So just wish you good luck, and sincerely try and negotiate with the tenant to get them out. The last thing you want to do is get bogged down in possession proceedings, because obviously it's not, just getting the judgment is one thing, then trying to get the possession order enforced with bailiffs is another. It's going to take months, if not a good 12, 18 months, I would say, for most possession proceedings.
Yeah, that's it. So thank you all very much for attending today, and I hope it has been informative. I know it is a bit heavy, but you've definitely done the right thing by coming on this webinar to learn more about our situation. So really hope to keep connecting with you guys. Say thank you very much for your time, Marcus. It's been great doing this with you. No doubt.
It's been great fun.
Yeah, it's been good fun. Yeah, we're just really sad, aren't we? We just love housing and tenant law stuff. So no doubt there'll be more changes on the horizon. So again, we'll let you all guys know if we do this again. Hopefully we will. So hope you all stay safe, take care, and we'll see you on the other side. Bye for now.
Cheers. All the best.
Bye.
Bye-bye.